Yeah, I'll let him.
That we waited.
Okay.
Thank you.
You did? I think so. Hold on just a second. Yeah, I'm just asking so I can, send it to, email it to the victims. Okay. Oh, that's good.
You say.
Hmm.
You
Then I
just
say, thank you. I've done this since January. Totally because the family, she does everything.
Also, it's not live stream.
Right.
All rise. The Superior Court of Fulton County, Atlanta District Circuit is now in session. The Honorable Charles M. Eaton is presiding. Court will now come to order.
Please be seated.
Good morning, Your Honor.
Good morning. Morning. Pull this up. Yeah. You're going to be. Okay, all right. Let me log in here. I think we have some people from that are. I think you sent me a link by email, right, Kathy? All right, let me find it. What?
At midnight.
At midnight? Good Lord. All right. All right, can you all hear me? Yep. I can hear myself. All right, good morning, everyone. This is the presiding bond calendar for Tuesday, August 6, 2024, 10 a.m. It looks like we have 6 cases. We have, I know, Ms. Clark representing the state. Who do we have representing the defendants?
Morning, Judge. Megan Eustace from the PD's office, handling cases for Ms. Samantha Beck today.
Okay. I'm not sure if I've met Miss Beck either, but PD. All right. Well, let's go ahead and start with position 1, 24P100471, Terry Solomon. Mr. Solomon, I assume they're all in custody. Otherwise, they wouldn't be asking for bond, right?
And yes, Your Honor, just for clarification, I believe that Mr. Terry Solomon did hire private. It was reflected in Odyssey, recently, so I'm not sure if that council would have received notice.
Well, we can ask Mr. Solomon that question. Thanks for the heads up. We'll look up this because it has back, but you said it would have been recent.
Yes.
Okay. Yeah, Mr. Solomon, if you could just come to the podium. I've got, obviously, we're going to be careful what you say because we're not sure who your attorney is, but there's no harm in asking me, did you hire a private attorney? Okay, who is that? Yeah, can you pull the microphone, or deputy, can one of y'all pull the microphone a little bit close to? So what is the name of your private attorney?
Name is Christina.
Her first name is Christina.
Yes, sir.
Do you know her last name?
No, sir, I don't
Alright.
remember.
Did she know about this today, or do you know she knew about it, or?
Yes, sir, I think she knew. Yes, sir.
Well, all I can do is we've got 6 cases. I can have you go back if she shows up. Within that timeline, we'll bring you back out and discuss it. If not, we're gonna have to reset your case because you can't, you gotta have representation, so.
Yes, sir. Will I be able to use a phone to try and contact her?
Okay, so she's gonna reach out to your attorney and we're gonna send you back for a minute. We'll update you, okay?
Yes, sir.
Okay, Mr. Solomon. Christina Sears, okay.
Oh, Your Honor, also on position 6, Justin Pate, the case that is the crimes against children's case. 88 Dion Peoples will be handling that case.
Okay,
He'll be here shortly. He's finishing up in Judge Thomas.
okay. All right, well, let's go ahead and move to Braxton then, position 2. Mr. Edie?
Correct, yeah.
Okay.
Good morning.
Good morning, how are you?
So far, so good.
Your Honor, if I may, during downtime, position number 5 was also recently indicted to Judge Richardson. I actually am assigned that case next door. I don't know if he was produced, but Mr. Freeman was indicted, so we won't be needing to hear that today.
Okay. So he'll be assigned Richardson's PD then?
Which is actually me, Your Honor, he knows.
Oh, okay.
Yes.
All right, so I won't need to bring him out then. You've already
I've
communicated
already
it.
seen
so-
him at the
Okay,
jail, and he's scheduled
okay.
to report with us on Friday.
okay, all right.
And Judge, for
Is he coming to
consideration,
the podium or are you having a seat?
let's see. For consideration, I have 2 letters of represent, characterization forms. I gave one to the,
Yeah, let me take a look at it. All right, let's see here. So you've got, all right, so this is 24P10045537. We have Mr. Braxton Johnson, who's present in the courtroom, joined by his attorney, Mr. Edie. And we have Ms. Clark representing the state. Everybody's present in the courtroom. Go ahead, Mr. Edie.
thank you, Your Honor.
So you're fine with your client sitting at the
Yes.
table? Okay.
Your Yana, just address the Yala factors here. I just start with the basis that Mr. Braxton here before you is 21 years old, with the charges that you have there before you, one count. Been in, I believe, since about June at this time. Um, uh, the risk that we have here that we just addressed there is he actually is born in Alabama, had plans on moving here. He was here at the time of meeting with a few family members to help him in the process of looking around some places to find an address, which he was able to obtain therefore later and after with his mom. So there's high intentions that he will be here upon him getting a bond, and that a residence at the location here, if the court was to grant a bond to allow him to be stayed here in Atlanta, that would be 100% plausible to do so, and that address can be provided to you as his mom and his dad is right here to the left of me, if you may stand. I have traveled to every court appearance here, maybe seated, in representation and as far as working with me and my office on his representation. So we're opposed that he's not a flight risk, Your Honor, and that he has intentions on coming to every court case, every court appearance upon being released for a given bond at any moment upon us getting. We understand that there's some tests and things done, so we do assume that, and I may be wrong, but high assumption that this case may take some time to go out throughout getting tests and lab results that actually coming from different states. The results and stuff was tested back in Tennessee, so we don't know that process and how long that may take. So we ask that that would be strong into consideration. So I will pose that he's not a flight risk. As I go on to prong 2, Your Honor, I will pose that he's not a significant risk, a danger to the community, as he has 2 self-centered jobs that he's been working. One of them is the familiar with Toro cars, in which he has 3 cars in which he works with a family member as well. And they rent out Toro cars, highly expensive cars, and which was doing very great in the business of doing so here in Atlanta throughout the summer. He's been doing that for about 2 years. He started off that process by actually just working at cleaning cars at a cleaning car service, and then worked his way up. So he has a fascination for cars. I do believe that in the process, he do anticipate going to get some type of certified mechanic degree to do so. He is a high school graduate, has no kids, and then no criminal background, which leads me into prong 3, obviously. Any risk to commit any felony while out on bond. He has no criminal background, has never been arrested, nothing in sight of even maybe a few parking tickets, speeding tickets, and I would be justified by saying that I'm actually guessing in that aspect, and I don't believe that that is to be true, that he has a clear background in that aspect. So the only thing to predict the future, again, other than the allegations itself, is what's in his background, and his background is a clean slate. Going on to the last prong, Your Honor, which is the arrest to intimidate any witnesses and things of that nature. Now, I'll try not to ease too much into the facts. I was able to conduct the preliminary hearing. It was a thorough investigation being done. So my understanding from what I have learned at the investigation, and please cut me off if you feel I'm going too far into the facts, but I just want to give out a few things that I found to be very important. That the communication with the female individual here at this point was someone that they met online. They had some distinctive communications via Instagram before leading into text messages. So I would pose that he's not a risk to intimidate her because they don't have any prior relationship before then. And that my understanding of what was communicated within that was for services. And what it just took as the belief that services was to be rendered in some type of form of payment later down the line is what we have. And then it was to no form of satisfaction from one party to the other, which then led to a 2-week or a week time frame being passed by and going all the way home to Tennessee before she decided to then cry out after attempting to reach out to say, can I get my form of payment to her satisfaction. Wasn't done so. Rate was great. She ended up getting a DNA test. So yes, we have would be no objection that it was consensual sex to the portion of what we have, and then something just went bad. So we'll say that he has no communication with her. Actually, him blocking her and deleting her is what led to after the allegations, because as long as she was able to communicate with him and try to get something out, there was nothing. Once he communicated, blocked, ultimately we end up with that. So we'll say that he is no risk to intimidate the witness. He does not know her. He's okay with 100% stay away. Any communications from her, any third parties, there's a few numbers that he will probably be able to provide that was being called from other people that was in her distinction. So we can get those numbers to put those on blocks. So ultimately, Jan, I'll say that it looks to me that he satisfies all four prongs as we go down the list of Ayala factors. And again, we're here to determine, obviously, on him being able to show back up for court, be able to answer the charges as before him, in which I believe he is in essence to do so. His family is in full support to do so. Has some great letters of recommendations. One of them, characterization letters, come from a police officer himself who actually has been working with him as a rearing person. So he has a lot of male figures, which is something that tends to lack in the community. So what I gave you before is his father was actually his stepfather who raised him, and then have his father in his life, and now another police officer who has been more of an ideal type of person. So other than that, I think he's a great ideal candidate for bond. So we had asked for a bond to not to exceed 75,000. The judge, the reason why I asked for that number is when I come and ask for bonds, I tend to not want to feel like I'm a waste of the court's time. I'm giving you a number that I believe the family can come up with, we have discussions about, and that can be posted. So you won't have to give me a bond and then have me coming back 45 days later saying, hey, Mr. Edie, you asked for this bond and now you want a reduction because the family can't make it, which make this hearing all fruitful. So in that case, not to exceed $75,000, that bond will be able to be posted within a reasonable amount of time, and then allow him to move on to his family, move on with his life, and then honestly get to the purpose of preparation to be able to defend himself in this case, which we believe will be carried all the way out through with the not guilty plea. So that's what I would have for you. And again, we have no objections to anything that the court may impose there and after, such as any type of curfew, ankle monitor for the time being, which then puts the thorn on his head to actually abide by any rules that you may put. And if he was not to follow those things, he comes back before you for a revocation, and it's all on him. So we ask that the bond not to exceed $75,000. Thank you.
All right, Ms. Clark?
Good morning, Your Honor. Your Honor, despite counsel opposite's claim to the contrary, this defendant is the definition of a high risk when that is outlined in the Ayala factors. The defendant is, first of all, is poses no significant risk, the first factor of Ayala factor. He does pose a significant risk of fleeing from the jurisdiction of the court. In the pretrial report for pretrial services, he does have an FTA, one FTA, where he has in a prior instance, he has failed to appear for a court proceeding. So in prior instances, he has failed to appear. Next, poses a significant risk to commit significant risk to persons or property. Based on the nature of the charges in this case, Your Honor, this is not a crime of criminal damage to property. Your Honor, this is a crime of rape in this case. And the violent nature of the crime, based on the charges in this case, and the circumstances behind the case, the defendant poses a risk. Your Honor, also, the letters of recommendation here that have been provided by counsel, the state challenges the authentication of these letters that are actually copies that we don't know where these letters are from. We also, the fact that the defendant is from out of state, counsel opposite indicated that the defendant does not have a job. He has no community ties. He's from out of state. He is not employed here. He's not employed. He did not indicate that he is employed in Alabama, for that matter. This is not these alleged recommendation letters. It's not from an employer. There is a risk of intimidation of the witness, the victim in this case, because there was a contact that was made where these individuals met online. and this was their first encounter where they met in person for the first time, this defendant took advantage of their first encounter meeting in person, and he raped her. Which indicates that this individual is a threat to society.
Well, that's a little bit of a circular argument. I mean, those are your charges, obviously. But,
Well, Your Honor, to your point, Your Honor, you may view it as a circular argument, but Your Honor, based on the evidence that was presented at the preliminary hearing, that was the preliminary hearing that was held in this case on July 18th, there was probable cause that was found by the Superior Court in this case.
no.
That rose above a circular argument, that found that it was sufficient grounds to keep this defendant held in custody. So, Your Honor, in this case, being that the defendant knows who the victim is in this case, being that the defendant has failed to appear for a prior court hearing.
But I mean, you didn't specify, was it, what court, where, what was the, what was the failure to appear?
One moment, Your Honor.
You're going to have an opportunity to respond, so.
I just have a copy of the pretrial report. I can get that information. I can provide a copy of the court, a copy of the pretrial report that has the FTA on here. I can, if the court will give me a few moments, I can provide the specific FTA.
Yeah, I mean, since you brought it up, I mean, to me, an FTA isn't necessarily binary. I mean, I'd like to know a little bit of the background on that
And I
before we,
understand But in all fairness, Your Honor, most of the time, if you refer back to when you did have criminal court, we would normally have a pretrial person here. Or
yeah, no,
yeah.
and I get it. And
And,
this is preliminary and there's
Right.
not a lot of information from either side, but I guess let's just move on and let me hear what the defendant has to say.
Right, but what
at
I'm
this
saying,
point.
to my point, what I'm saying is this pretrial report is available to the pretrial services, and a pretrial person would normally be here And that pretrial person could look it up and actually provide us the actual specific FTA, because this report is available to them. We don't have a pretrial person here
Yeah.
because you're on family court side now.
Yeah.
So that's what I'm saying. Like, this is something that is normally available, but you don't do criminal court. So,
Yeah.
but if you,
Well, it is what it is. Let me hear from the defendant at this point.
Yeah, Shauna. To start.
and the factual, before you respond, the factual basis, I had no intention of referring to the facts, but counsel opposite did refer to the facts of the incident, but probable cause was established.
Well, I get that. We wouldn't be sitting here if it wasn't. He delved into the facts a bit just as it related to intimidation of the witness. I would have stopped him if I felt like it went.
Right.
It's sort of irrelevant to me anyway, because I'm a family law judge who just is having a preliminary bond hearing. It won't be my case. So there's no point in foreshadowing the ultimate case here with me. But go ahead, Mr. Edie.
Yeah, Shauna. And to find that case, as stated before, that I believe if it was anything, it was a speeding ticket, and to put it on me if it wasn't. I did find that ticket. It's a ticket here in Atlanta Municipal Court. The court date was for 7/11/2024. The first arraignment, the ticket was a speeding ticket and a seatbelt ticket. He was cited on 6/18/2024 and had his arraignment on 7/11/2024. And that was in the Atlanta Municipal Court, which was, I believe, just quite a few days before the arrest here. And it just happens to say that I guess the address on file, I guess it just like sent back, but it was
So there was a failure to appear associated with the speeding ticket.
with a speeding ticket, yes.
Okay.
And I have that here on, you can go on the NC
Okay.
courts.
All
The
right.
case number,
You're represented by counsel, so I'd rather just hear from the counsel.
24 TR 0.
In the end, it's going to help you anyway. That's why you hired him. He knows what he's doing.
Yes, so 3982 would be that case number. So that would be the, if it was a FT, and again, I was to say to put it on me if that was something else on there. And just to address the last two issues that I, again, wanted to bring up, it seems as if the big issue is more so of his ties and community here. He also have expressed, and I failed to mention, so that he has very high intentions on going to the military. And again, he do have a job and he has family here in which he would move here to help his family out, which they were able to legally, which they have been doing for quite some time, for my understanding, the last 2 years, and have been doing good within that business to be able to maintain himself. Rental cars, in which is very similar to Airbnb instead of hotels, the Airbnb, the car version of it, in which they have 3 cars. He started off as cleaning cars, and then they have Airbnbs, which is something that's very big here in Atlanta with the type of things that they do. So he was able to establish that. He has expressed that he wants to move into the military. Again, at 21 years old, we're not here to establish that he has some type of hierarchy type of a job. He's beginning his life. He wants to be able to establish what he's doing, afforded that opportunity, Judge. And what we're asking you for here today is to allow him to continue that opportunity to be somewhat of a productive citizen. And if there's any opposition to it, then the court has those means to be able to let him know that if you are not able to do those things, these are your consequences, such as any type of classes, curfews, only be able to meet with your attorney for the purposes of X, Y, and Z, obtain a job if you needed to have a 9 to 5 job with a taxable employee type of thing. He's able to give that opportunity, and that's actually up to the court to do so rather than just actually leaving him in here to sit for some time. And again, the alleged victim in this case lives in Tennessee, has no ties here.
Where would he stay? Where would he be staying?
Go for 1 second, Joe. The address is 741 Simon, Simon, Park Circle. That's in Lawrenceville, Georgia, 30045. And that is the first cousin to his mom, who was there. And she was able to confirm that address, that he would be allowed to stay there for that opportunity. And again, for the first 90-day, Judge, if you decided that you wanted to put a 24-hour curfew to abide by him being here and attempting to do anything of the sort that would be not in conveyance of the court, he's given that opportunity to do so. And we can revisit this back in 90 days if the bonds was to say that he hasn't been in compliance of anything. So a curfew would not be a reach to put and apply on to him to be having a ankle monitor to be paid for by the state to do so. And then afterwards, if he are able to obtain a job to the satisfaction of the court, we can come back, revisit, send you those documents, and that will allow for him to be able to just move around from the period of whether it's 8 to 6, 9 to 5, whatever those hours to get to court, to get to work and back to work, we can be able to do so. It basically puts the thorn on his head to show you he's able to abide by what you will be asking for, Judge, and that's the purpose of here today.
I'm not sure the state's even paying for ankle monitors though now, or have they fixed
No.
that?
Understood. And
Well, I see Miss Clark, you're itching for another bite. Go ahead, Miss Clark.
Your Honor, the state can appreciate the fact that the first cousin of the mom, but we don't know who this first cousin is. And whether this person is a convicted felon, anything about this person, whether verification of this, or we need to be able to be assured if there is like no verification of what this person is going to be doing, we need to be able to be assured of the fact the state is not being able, we're not funding the ankle monitor. This individual does not have a job at this point.
Yeah.
Um,
All right. Well, I've heard those arguments already. So I'm going to give him bond. I'm going to set it at $100,000. He's going to be on 24-hour ankle monitor. That's going to be up to him. And he's going to, 24-hour curfew with an ankle monitor at this address that you gave me. No social media, no drugs or alcohol, no weapons. What else am I missing as far as conditions, Ms. Clark?
and also, Your Honor, we would be asking for $100,000 good bond.
Yes, $100,000 good bond. And what other conditions have I missed with that you would?
No social media.
Said no social media, no contact with the victim, any family members of the victim, or any other witnesses or possible witnesses to the crime, either direct or indirect, to the alleged crime. Am I missing anything else?
Just basically that if no curfew.
I've got him on 24-hour
Okay, 24
house
hour.
arrest with an ankle monitor.
Think you covered it, Judge.
Okay.
And upon him getting a job, we can submit that to the court, which will.
Well, given that, some of these indictments have run slow, you alluded to it. If it's still unindicted, I'll give you the opportunity to come back in 3 months. So,
Understood.
all right.
Thank you, Your Honor. That concludes my
Carmen?
business. Appreciate it.
Yeah, and will you send the bond order to Ms. Robinson?
Will do.
Okay. Thank you. You're excused.
Thank you, Your Honor.
All right. All right.
Good morning, Judge.
Hey, Mr. Peoples, how are you?
I'm well, and yourself?
Good.
I believe we're here for Justin Pate.
That is correct. Good morning, Judge. Flyway, Mr. Payne, good to see you.
Good to see you, Mr. Fly Lawyer. I see you got your placeholder over there, so.
Always a
So-
pleasure, Judge.
Oh, so you're wanting to, y'all want to go right now?
If, at the court's pleasure, Your Honor.
Sure.
And it's the defense's motion,
Yeah.
so we're here.
We're ready, Judge.
All right, we'll go ahead and bring out Mr. Pate then.
Mr. Peoples, how do you spell your first name?
Gion. Yes, thank you so much.
Yeah.
Ms. Sears, she actually,
How you doing, Mr. Payne?
and-
Sit right here. How you doing? Good to see you.
Okay.
See about my sister.
Okay. All right. So this is position 624P I005063. Justin Pate, who's present in the courtroom and is joined by his attorney, Mr. Patterson, and we have Mr. Peoples representing the state. Go ahead, Mr. Patterson.
Yes.
And Judge, I would just ask, as we proceed, we refer to the victim by her initials.
Okay.
I'll just say Victor.
Okay.
Yes.
Okay.
Good morning, Judge. Your Honor, Mr. Pate is 42 years old. He's single. He has 3 kids, 12-year-old son, 11-year-old girl, and a 2-year-old boy. He works he recycles cooking oil throughout the city. His mom is Teresa Pate, and she's present, and his dad is Kerry King, and he's present. Your Honor, my client is from the Atlanta area. My client, Your Honor, is accused of allegedly putting his finger inside the victim, allegedly while he was drunk. He's also accused, according to the victim, of seeing the semen come out of his penis while he was drunk, doing these allegations. Your Honor,
What is the age of the victim again?
8 years old, Your Honor.
8 years. Okay.
Your Honor, once this case gets to trial, the evidence will show that not only is the victim's mother has a history of setting people up like this, and also the victim mother even set up my client's mother, made the same allegations against my client's mother. So this is not your typical aggravated child molestation. This is an intertwined family revenge type factor. So, Your Honor, at this time, may I call Teresa Pate to the stand? Ms. Pate.
Why are you bringing Miss Pate to the stand, Mr. Patterson?
She's going to talk about, Your Honor, that this is a history of the victim's mother to actually accuse.
I would object, Your Honor, to that. I mean,
Then I'm just going to call for the Ayala factors, Your Honor.
I'd prefer to keep it on the LIF.
Absolutely.
Right. Thank you, Your Honor.
I'm right to the stand. Judge is not. Just have a seat. Will you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you may lower your hand, and
Pate, before Mr. Patterson begins, you probably heard me sort of alluding to it. We're not having a trial right now. We're just deciding whether or not Mr. Pate ought to have bond. And so it's pretty narrow set of factors that we look at on that. Go ahead, Mr. Patterson.
and Justin Pate is your son, is that correct?
Can you spell your name, state my name?
My name, Teresa, last name, P as in Paul, Pate.
And Ms. Pate, Justin is your son, is that correct?
That is correct.
And tell the court what you know about his character when he was growing up and the type of person he is.
First of all, when he was a little boy, he did not speak until he was 3 years old. And when he spoke, I had to take him to John F. Kennedy daycare, and they put him in a speech program because when he talked, it was backwards. You have to figure it out, what he was actually saying. He did that all the way up to middle school. However, there are a lot of times he still speak where you don't quite understand what he's saying. But his character, he's always been a type of person that wants to help you and resolve issues that you might have, like his brother, me. He helps me. His character is a helping person.
Okay.
And he's an individual that tried to do things for himself as well as help others. And he's helped in my home, so much.
And if the judge granted him bond, do you think that he would commit any crime
No.
while out on bond?
No, it's
Do you
not.
think that he would intimidate any witnesses whatsoever?
No, sir.
And do you think that he would show up to court?
Of course.
And do you think that he would interfere with the administration of justice?
No.
Okay. And if the judge granted him bond, where would he be living?
He can live with me
And where is that?
or,
Where is that?
I'm in a senior apartment right now, due to my health, and Justin also helped me with my situation, my health situation.
And where was Justin staying at the time of this incident?
Off of Camp Creek.
And is that where the alleged victim lived as well? The same address or a different
No,
address?
she lived with me.
Okay. And,
1395 Hartford Avenue is where we live. I
Okay.
lived there for 40 years. I just moved due to the fact.
and do you know Justin's address, since he didn't live with the alleged victim? What was Justin's address?
I don't know the exact, I never know address. I'm just
Okay.
now learning where I'm at
But it was
now.
in Atlanta?
It's in Atlanta.
Okay. Thank you so much. No
Mhm.
further questions, Your Honor.
Okay.
Just brief recross, Your Honor.
Okay.
You said, thank you for joining us this morning. You said that you're sure that he would return to court. Has he ever missed court before, to your knowledge?
Not that I know of, no.
Okay, thank you.
I mean, I don't know. I can't answer when you're a grown man.
Okay, thank you.
You can step down, ma'am.
Okay. You're excused.
It's nothing but my heart, I'm sorry.
Okay. And Your Honor, I call Mr. Kane.
Okay.
Okay. Hey, Mr. Kane, raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And you may lower your hand. And Mr. Pate is your son, is that correct?
State and spell your name for the record.
Kerry King, that's KerryCain.
And Mr. Pate is your son, is that correct?
Yes.
And tell us, if you will, about his upbringing and the character that he has.
Well, he has, his character is great because, like his mom just previously stated, he loved helping people. That's how he was taught by me and her to always, help people. Then I also told him that you can't help everybody. And he understand that.
And if I'm sorry, I didn't mean to cut you off. Go right ahead.
And what he's doing is trying to raise his children in that same manner from what he was taught as he grew up.
And what county do you live in?
I live in Putnam County.
Putnam County?
Yes,
Would that be Edenton, Georgia?
Edenton, Georgia.
Okay, and if the judge granted him bond, would you be opposed to him living with you if the judge granted him a bond?
No, I would not.
Okay, and that's in Edenton, Georgia?
Yes,
And if the judge decided to give him an ankle monitor, would you be opposed to that?
no,
Okay, and what about a curfew?
no,
Okay, and do you think if the judge granted him a bond, would he commit a crime while he's out on bond?
no, he
Do
wouldn't.
you think that he would show up to court?
Yes, he would show up.
And do you think that he would intimidate any witnesses?
No,
And do you think that he would obstruct the administration of justice?
no, he would not.
Okay, so you feel pretty confident that if the judge grants him a bond, that he would abide by all the bond conditions, whatever they may be, that the judge imposed upon him?
Yes, I do.
Okay, no further questions, Your Honor.
Cross.
No questions, Your Honor.
Okay. You're excused.
Your Honor, that is all we have in terms of witnesses.
Okay.
Morning, Your Honor, if it pleases the court. The state is opposed to bond, Your Honor. At this time, there is a sole count in the warrants for aggravated child molestation. Your Honor, the the victim made an outcry on October 24th of 2023 to the forensic interviewer, the 8-year-old victim, KP, was taken to the Georgia Center for Child Advocacy. During that interview, she disclosed that she was living with her grandmother, Miss Teresa. She disclosed that while she lived there, the alleged suspect, who was her uncle, Mr. Justin Pate, the defendant, she disclosed that the defendant would touch on her and her siblings. She disclosed specifically one incident where the defendant came into her bed and she believed that he was drunk and he began touching her, stating that she was 8 years old at the time. He touched her private parts, both in and out, with his fingers. She disclosed that the sounds that he would make during the incident, and she was able to describe it on identify the parts of his body that she witnessed on an anatomical drawing. She also disclosed that something white came out of his penis and it fell on the floor while he was playing with his private parts using his hands. Your Honor, the victim, KP, advised that she lived with her uncle and Miss Teresa since she had been 6 years old. Your Honor, she was also able to identify the defendant through a single photo. Your Honor, the state is opposed vehemently to bond, citing danger to the witnesses and risk of reoffending while on bond. The state is aware of that that the defendant has a possession of a firearm by a convicted felon or first offender out of Fulton County in 2010. He also has a failure to appear from 2011, another one, 2 out of Cobb County. And then he was also convicted of aggravated assault in Fulton County in 2014. Your Honor, the state is opposed to bond, citing danger to the witnesses. We believe that the heinous nature of these charges, as well as the facts that the state has just recited to the court, we believe that bond should be denied at this time, citing, again, danger to the community, danger to the witnesses, risk of reoffending while on bond, and the state is also concerned that he may not return to court.
Okay.
Thank you, Your Honor.
Mr. Patterson?
Your Honor, based upon the testimony from his mother and father, we believe that it would not be appropriate for him to live with his mother because she's at a senior home. That would be completely inappropriate. But his father down in Edenton, Georgia, that would certainly be an appropriate place for him to live, which is nowhere near, the alleged victim. We would also ask, Your Honor, that the court not only grant a bond, but do a ankle monitor as well as a curfew, and that he be banned from Fulton County except to come to court and to his lawyer's office. We would also assert, Your Honor, that a bond in the amount, these are very serious charges, although the evidence will show down the road that he's innocent of these charges. We believe a bond in the amount of $50,000 would be sufficient to make sure that he returns to court, as well as an ankle monitor and a curfew, and that he be banned from Fulton County and live with his father down in Edenton, Georgia, which is Putnam County. Your Honor, as the court is aware, the purpose of bond is not to punish a person, but is to ensure that the person returns to court. In fact, the Supreme Court of Georgia has indicated it favors a bond simply because he's cloaked with the presumption of innocence. We would ask the court to grant a bond in the amount of $50,000, ban him from Fulton County, ban him from any contact with the alleged victim, and to require that he live in Putnam County.
Okay. I'm going to deny Mr. Pate bond, given his failure to appear and his past criminal record. And I'll base that on intimidation of witnesses, danger to the community, and risk of flight.
Your Honor, that is all we have. May I be excused?
You're excused.
Thank you, Your Honor. I believe that concludes my business as well. Have a good one.
You too. Good to see you, Mr. Peebles.
You as
And
well. Always a pleasure, Judge.
You as well, Mr. Patterson.
Pleasure to see the court, Your Honor.
All right, we'll go to position 3 now, Michael Anthony Anderson.
Did you see that chat in this part?
Oh, I'm so sorry. No.
No, there was a chat on Zoom.
I'm not logged on.
Okay.
Can you send me the link? You know,
This is, I don't know.
Let me see real quick here. Seen it now? I mean,
can you see? Can you
I'll
mind?
tell you what, I mean,
Do you mind
it's in a
sending me-
public chat. It just says I'm the victim of the case of Michael Anderson. Will I be able to speak?
Yes, I don't have the Zoom link. That's why.
Okay.
Yes, yes, she can speak. But can you email me the chat? I don't have it. Oh, that's okay.
But you're gonna have to get that link to her somehow.
Now she has it, Miss Connolly.
Oh, she just wanting to know, okay.
Oh, yes, ma'am.
Yeah, obviously, she's on the chat.
Okay, yeah.
I should have. Okay, so while you're doing that, we'll go ahead and call this case, position 324 PI 004716, Michael Anthony Anderson, who's present in the courtroom with his attorney, Miss Eustace. And we have Miss Clark representing the state. Go ahead, Miss Eustace.
Yes, Your Honor. In front of you is not Mr. Conlon, that's Mr. Anderson. I was looking at the victim's name. My apologies. We are asking for a reasonable bond to be set today. He is 34 years old and on the calendar is charged with 1 count of rape. I do, for Your Honor, and I have shown Ms. Clark, have proof of employment if I may approach.
You may. Thank you.
As you see on that paperwork, he has been gainfully employed since March of this year. That letter is dated August 1st of this year. He is with a union where he does labor and freight work, setting up shows, setting up concerts, and setting up venue events around the Atlanta area. He also is currently enrolled in Atlanta Technical College where he is studying business and is about halfway through his bachelor's. So he does have ties to the community, both employment and through education. His mother is also here, if you'll stand up. Thank you. And showing her support, she actually is the one who was able to get me that proof of employment for me. Mr. Anderson also is currently voluntarily participating in the PAD program, the Policing Alternatives Diversion Program. He did that on his own. It's not court ordered. And he also helps out with Chris 180 as a volunteer. So he has significant positive ties to the community. He is gainfully employed again and also in school. At this time, we would be asking for a reasonable bond to be set with any conditions such as staying away from any addresses where this occurred, having no contact with Ms. Conley Young. Even if Your Honor were to impose an ankle monitor, it is my understanding that we have been able to get state-funded ankle monitors. With my bond orders in the past few weeks, I have been able to get some clients, ones that we say if available, county funded. They're having ankle monitors come back in, and there's a certain number that are set aside for our county funded clients. So I would ask if Your Honor would impose an ankle monitor that we be permitted to try to see if there would be a county funded one, since you will have to come up with bond money. And I will pass this over and we'll save the last word if possible, Your Honor.
Okay, go ahead, Ms. Clark.
Your Honor, this, wait a minute. Oh, let me,
Somehow your computer is probably unmuted.
oh, let me,
No, the microphone stays on, but your computer gets muted.
okay,
That's where the echo comes from.
testing, okay,
Well, your microphone's off now and we need that on.
okay, on.
Yeah,
Okay,
now-
what about now?
yeah, that's good. That's
Okay.
good.
I'm gonna let, Miss Connolly Young, I'm gonna allow her to speak before me. Is that okay?
Yeah, that's okay. Will,
Miss Young,
where is she?
can she hear me?
Yes, I can hear you.
You can go ahead and speak.
Well, wait a minute. I mean, we need to swear her in.
Okay.
And, need her video on.
Okay.
And I think Ms. Young's been patiently waiting, but I will say, and I certainly don't want to seem unsympathetic to anybody's position here, but we're not here to try the case.
Right.
But if you could swear your,
Witness.
Ms. Young in, please.
Okay, I'm gonna swear you in and basically you, swear you in and, I'll ask you questions and we're gonna, limit it only to, strictly to, just your position on bond. Not, testimony as it relates to, the actual allegations, okay?
Okay.
All right,
Can you swear her in?
okay.
And Ms. Young, just for the record, I won't even be trying the case ultimately. So, just to try to
Okay.
put some boundaries on testimony.
Please raise your right hand. Do you swear or affirm that the testimony testimony and evidence that you shall provide this court shall be the truth, the whole
Yes.
truth?
Yes.
So help you God.
If you could spell your name for the record, state and spell your name, Ms. Young.
SYMONE, last name CONLEY-YOUNG.
Okay. All right, go ahead, Ms. Clark.
Where do you live?
In Michigan.
And what county do you live in?
Wayne County.
And have you ever lived in Atlanta?
No.
Do you know the defendant in this case?
No.
How do you feel about the defendant? Would you like to make a statement about the defendant with a bond in this case?
Yes.
Okay, go ahead.
I'm just trying to not get too distracted and get into the whole thing. So as far as the bond, I didn't even feel comfortable even saying what county I stayed in because his mother is there, and his mother have been trying to find my location, and I don't trust it. I feel uncomfortable with unsafe because she's just been trying to put so much together to figure out where I stay, and I have her on recording, doing it, and it's for my safety and my daughter. I'm a single mom. I'm with my kid by myself all the time, and I just don't feel comfortable for him to kind of try to come find me and do anything to me and my daughter because of the situation he did to me, especially the fact that he tried to already attack me when the whole thing was going on of the rape. So I definitely feel like it's dangerous. Like,
How does the sexual assault make you feel?
I'm not myself no more. I know I'm not myself. Um, uh, I got so many emotions. Mm. It makes me feel like
I, I,
woman was taken from me.
Ms. Conley Young, I don't want to be unsympathetic, but I don't know if how the alleged sexual assault makes her feel is relevant to my decision right now.
Are you afraid?
It made me feel like my
Okay.
woman.
Are you afraid?
Protect myself. I feel like I didn't, like,
Are you afraid of the defendant being released?
of course. Yes, his mom keep looking for me. She keeps trying to find my location. I have recording of that. He attacks me when I confronted him about the stuff. Like, why did you rape me? I was intoxicated. Why would you do that? He's trying to attack me. He snatched my chain off my neck. Yes, I am scared for my life. I have a daughter. I'm a single mom by myself. I barely have family, you know.
How do you know that was him?
What do you mean?
How do you know that his mom is the one that keeps trying to contact you?
Because I was during a time when I was still in Atlanta, I was still located with his cousin, which is the witness, and he's my witness. He's going against him on the case. He talks to my friend of mine, which we all made a statement to the police and called the police. And he
Donna,
was
I have to object. I mean, I don't see how this is relevant to
he was on the
the bond
phone.
factors today.
Well, Your Honor, okay.
On the
So,
phone, and she was on her Facebook page talking on the phone, and I recorded her Facebook on the phone.
hold on first. Please pause for a second, Ms. Connell. So, Your Honor, with all due respect, normally, and I'm just doing it the way you've asked, normally the victim is allowed to just make a statement, whatever statement they want to make. You wanted to do it out of respect for how you do your court because a judge is allowed to handle the court the way they want to. A victim is normally allowed to just basically make whatever statement they want to make. But you said you wanted to hear it and have her swear in and make whatever statement she wanted to make. So I'm, out of respect for you, I'm having her do it the way you're wanting, the format you're wanting to do it. So.
Ms. Eustace, how do you respond to that? That normally the victim isn't even sworn in and can just make any statement. They just have the floor to make whatever statement they want to make.
Your Honor, I am sympathetic to a victim's rights to speak. However, it has to be on track or on par with what is being handled by the court. And today, that is simply bond. So at this point, it is Ayala. I'm not saying she cannot speak to her fear, but all of these extra witnesses and parties' names, this is not an evidentiary hearing of any capacity, Your Honor. So not having any of this information relevant to today's hearing.
I guess it's an interesting point, Ms. Clark. I mean, what is the relevance to me and my decision that's in front of me right now?
Okay, so in that case, then allow me to go ahead and just allow me to respond to.
I mean, and I do give leeway here, and I don't mean to handcuff the victim to where she can't say anything. But as I said before, I mean, this isn't even foreshadowing here because I'm not going to have the case. All I'm focused on right now is whether to grant bond.
Okay, so allow me to go ahead and in lieu of that, just because you brought to my attention that because I wasn't on Zoom. So you brought to my attention that the victim was wanted to make her statement. And so I basically just was like, okay, she wanted to make her statement. So I basically was gonna allow her to make her statement. And then you said, well, not here to try the case or whatever. So I basically was like, you said, are you gonna swear her in? So I took the prompt from you that basically you wanted to ask her questions, right? So from that, so allow me to go ahead and respond to counsel opposite's, art bond argument. And then she can make whatever statement she wants to make, since counsel opposite seems to have a problem with her making her statement.
Well, let's just get to like I said, I've had no issue with her speaking to the fear that she may have as a result of the charges that are against Mr. Anderson.
Because then that way she can just basically say whatever her fears are, and she can make whatever statement she has.
Yeah, I mean, look, I've already told you I'll give some leeway here. It is the victim in all of this, but I also said I don't see any point in having a trial. But let's just go ahead, Ms. Clark.
Right, because normally she would have been like, oh, I have a fear of him getting out because.
Yeah, well, I'll tell you what, let's just go ahead with it.
Right.
Okay.
And then I won't have to ask her questions.
Sure, we're starting to get redundant.
Right.
Said that I had a fear of him getting out because his mom been trying to contact me. And he already attacked me. His mom been trying to track me. I have a daughter. That's been stated when I first talked.
Yep. Go ahead, Ms. Clark, and you've got the victim's mother raising her hand, but I don't really want to hear it. I mean, not the defendant's mother raising her hand in the back, but we don't really need to hear from her right now. Go ahead, Ms. Clark. Do you have anything else with the victim?
No, if Miss Connolly Young has concluded her statement, then I'll just go into my my argument.
Okay.
One moment, Your Honor.
You need a break. After this. All
Your Honor, is it possible for me to use the restroom?
right. We'll take a 5-minute break.
Sorry, Miss.
Oh, I don't think you're going to get any opposition from Ms. Meyer on this.
You got something to be signed?
Oh, no, I just wanted a piece of clarification.
What? Go ahead and finish.
You need to go with.
What's up?
Yes.
You gotta come. Give me 1 second. I got you in the registry too. Oh, okay.
This,
This is what you're looking for. Okay, who sent you up here?
this came.
That for a presiding matter?
I don't know, let me let you look at it. It's not a presiding matter.
Oh,
So what am I asking her to do for you? What do you want?
I'm not sure, I was trying to figure out a date that my name is spelled wrong.
And it's for family court?
Oh, really? But they have this court, so I'm not sure. Family.
I don't think they sent him up here. It's not a family matter. Just wanted to know, I didn't shake his name is wrong, but what court, they just told him to come to this.
state court.
He said this had nothing to do with this. But it says solicitor, so that'll be a state court. J-160 sent you over here?
J3, I did J150, sent me to J3 and J3 should put right here.
And who is this?
That's the land that was built on the.
I'll be right back.
But it's my court, that's my court, they said that's my court.
This is gonna be your court date in this courtroom?
They want to get clear. That's all. What it is, you tell her, I said, it got, it's just, this.
Court. So it's been bound to the station.
See, I got two.
I'm finding.
We're gonna talk.
Okay, all right. Good to see you. It's always good to see you.
My pleasure.
Hey,
Hey, you get my text?
no, yeah, I saw,
Okay. So, yeah, this is the GCIC here. And it shows she was arrested in April of this year.
okay.
So you good?
Remember your,
Mhm.
tell me in a minute.
Okay, all right. Good.
Did you get a chance to make a copy?
I didn't, I haven't judged.
Can you get me a copy or? I will get you.
We'll just.
Hmm. Yeah.
You normally in.
Judge Richardson, Your Honor.
Oh, okay, right next door.
Yes.
Good friend of mine. All right, so we're back on the record here with Michael Anthony Anderson, Ms. Clark. Go ahead with your argument on the bond.
Okay. Your Honor, so, the state is opposed to bond in this case. The, defendant, based on the Ayala factors, Your Honor, the defendant is when looking at the Ayala factors, for number one, he does pose a significant risk of fleeing from jurisdiction. He has FTAs on his criminal history. Just looking at Georgia, and I will call out those specifically. He has one failure to appear Marietta City Court in 2013. For yeah. Yeah, Marietta City Court, and then under Atlanta PD, he has one for sexual battery in 2013, for Cobb County and Cobb State Court in 2014, for DUI. Fulton County State Sheriff's Department, he has one July 2nd, 2024. Defendant also, Your Honor, is a multi-state offender. And he does pose a significant risk of danger to a threat to committing significant threats to persons, community, property. He is a prior he has prior criminal history. In the state of Georgia, he has convictions in Georgia. He has a state conviction in Cobb State Court for sexual battery. And in Fulton, he has a Fulton State Court, he has a conviction for theft. In the state of Texas, he has a felony conviction for One moment, sorry. It's a conviction for forgery, credit card abuse in 2016. Is a misdemeanor conviction for 2015 for marijuana. He has a felony conviction in 2021 in Houston. Third conviction for in Texas for DUI. Third offense felony. Excuse me, Your Honor.
That's probably covered it. Anything else, Ms. Clark?
Still going, there's also a robbery conviction. I just want to make sure that there's a date. I have the date certain. There's a 2020, November 2023 conviction for assault, bodily injury, family member conviction out of the state of Texas.
All right, I've heard enough.
Okay.
Go ahead, Ms. Eustace. You got anything you want to add to?
Your Honor, just to note, I did hear one of the dates for the FTA was July the 2nd. That was actually the date he was taken into custody. So I would say that that is a little bit moot at that point. You can't fail to appear when you're being held in the jail. He does have some history. Again, a lot of it is alcohol related, Your Honor, hence why he is in the PAD program. We are not shying away from it. He is getting the help that he needs for that and has kind of turned another leaf. When it comes to some of the statements made by the victim, for the record, I'm not saying a victim should not be able to speak, Your Honor. I
Sure.
think that's what the state was kind of implying, and that's not at all what I said. I just think it needed to be honed in a little bit, and his mother is here. She is willing to take the stand and say her side of what's happening, but I don't think this hearing needs to be belabored any longer than it already has. We're just asking for a reasonable bond, considering all the circumstances,
Yeah.
Your Honor.
I mean, given his prior criminal record, some of it, what I would consider violent, and his FTAs, I'm going to deny bond, risk of flight, and threat of danger to the community, risk of committing, all four of them, and the risk of intimidating witnesses. So obviously, when the case gets indicted, there'll be another opportunity with another judge. You're
Thank you, Judge.
excused. Let's go ahead to position 4, and then I believe position, is that you, that's you, Miss Sears, right, back there? Yeah, good to see you again. So we'll do position 4, then we'll go to you, and that'll be it. So that's Baker is the one that we're bringing.
Your Honor, may I approach and get that paperwork back?
You may.
Thank you, Judge.
This paperwork?
Yes. Okay, Judge. Thank you. Bring out Baker.
Are you the GBI agent?
No, sir.
Okay.
I'm an
Oh,
investigator.
you're the GBI agent. All right. All right, 2 more and then we'll.
Judge Eaton, do you want to take him?
Do I what?
The GBI person?
What kind of warrant do you have?
Excuse me, Your Honor. Cell phone extraction warrants too.
How many?
Cell phone extraction warrants, 2 of them.
I'll do them after this, so we've got them in here. Okay. This is 24P1004717 DeMarcus Baker. He's present in the attorney with his, he's present in the courtroom with his attorney, Ms. Eustace, and we have Ms. Clark representing the state. Go ahead, Ms. Eustace.
Thank you, Your Honor. Mr. Baker is 26 years old and he has lived in the Atlanta area for 20+ years. A significant portion of his family does live here. He also has 2 children, twins that are about to be born. They're on the way as well, Your Honor. He does have a good address where he lives with his mother in the Atlanta area, has lived there for the past 6 years at that address. He also has a job doing or certificate doing heavy machine operation, which is what he does as well. We would be asking, Your Honor, for a reasonable bond. It is for a single count of rape on this this calendar as well. He's self-employed, but also works for Peachtree Movers, so he has 2 jobs here. And our request at this time would be a reasonably low bond. That way he can get out and help us as well. He too volunteers with Chris 180 of his own volition as well, Your Honor.
Okay. Ms. Clark?
Your Honor, looking at the Ayala factors, want to pull up the defendant's profile in Odyssey. Just 1 second, Your Honor. I had it open, but closed out on me. Your Honor, the state is asking for that bond be denied in this case. The defendant is a multi-state offender, Your Honor, in this case. Defendant has a criminal history, not only in this state, but also in the state of New York. Defendant has several probation violations, Your Honor, in the state of Georgia. Defendant is a convicted felon, Your Honor, and has shown that he will not comply with the law, triggering Ayala Factor 2, showing that he is a that he will not comply with. He is a threat to. He is a threat to property and persons. Your Honor, he has probation violations from 2018. Then when he's had it, his probation violated from 2018, then he turns around and has probation violated again 180 days after that. And then in 2022, in DeKalb County, his drug possession violation in 2022. But that was actually, correction on that, Your Honor, that was actually played down to a misdemeanor on that case, Your Honor. But he's shown that he, when he is out of custody, he has failed to comply with the law. Your Honor, we ask that based on the nature of the circumstances of the nature of the charges in this case and the defendants showing that he fails to comply with the law, and the fact that in the preliminary hearing in this case, there's a preliminary hearing scheduled. It appears on 8/15. In this case, we're asking, Your Honor, that bond be denied at this time, and that if you do grant a bond, we're asking for a bond of $175,000 of a straight cash bond with an ankle monitor at the defendant's expense. Defendant has shown, defendant has not provided or shown any community ties or any employment or anything that would indicate that he will appear for court or hearings or of anything. And based on the nature of the charges, we have no assurances that he will appear for court in this case. And until this case is indicted, we're asking, Your Honor, that bond be denied. Thank you.
Ms. Eustace?
I will keep this brief, Your Honor. His family's here, his children that are on the way are here, he has a job here, he's not leaving. He actually, during this hearing, even leaned over and said, would the judge even consider putting me on a monitor? So he is willing to do anything that Your Honor would require of him. Of note, the state indicating that he is unable to abide by the laws went out. He's been out of trouble, from what I heard, since 2018. So that's 5 years of him showing good credit and good ability, or a positive ability of being able to abide by the laws went out on the streets, Your Honor. I have also spoken with him. We would be asking for a $75,000 good bond.
Given the past criminal history and what I've heard today, I'm going to deny bond, the probation violations. I will say this, case isn't indicted in 3 months. You can come back in front of me and we can discuss this case further. And he'll have another opportunity, and perhaps we'll have more information at that time.
Thank you, Judge.
Okay, and I'm denied it based on all 4 of the factors. All right, let me take a brief recess and I'll meet with this agent, and we'll tee up the first one on the calendar.
Thank you. Good to see you, Judge.
And Your Honor, may I be excused as well? That concludes my
Wait a
business.
minute, who's doing first case? Is that?
It's on me, that's on me.
Oh, okay. It's one more. Okay, sorry, Your Honor.
Not me,
Okay,
Your Honor.
well, I'm still here. I'm doing it. Sorry.
Yeah.
All right, my bad.
You wouldn't have been so generous about me seeing the GBI agent if you,
No, I'm good. I'm good.
kidding. Come
All right.
on back. Kathy, let it through.
Huh?
She was asking if you want to go to the back.
No, you.
Oh, he's saying
Oh.
GBI per.
Sorry.
Okay, I'm good.
GBI going to the back.
How you like family court?
That's what I did before I did criminal, so
Oh, okay, okay.
I find it tedious.
Oh, okay. They ain't gonna work for us, huh?
Ms. Clark, you feeling okay today? You need to talk?
I do.
Why? You-
Okay,
I think you're stressed out.
You gotta go to the back.
Please, what good restaurant you got? I know you got something on there.
I got some.
You know, it's just that, yeah. What is it? Yes, you made phone service.
Yes, come on. Okay, we'll come on with one. Yes, sir, buddy.
Thank you.
Yes, ma'am.
Introduce me to your ADA.
Yeah, Christine,
Yes.
this is Christina Seals.
How are you?
Yeah, she used to be with our
I'm
office.
doing really well. It's nice to meet you. I'm gonna shake your hand when I come from here. I'm talking to my client. Yes, it'll be better.
Okay, so.
so it's,
So it's like I'm not together because I just got, yeah. So just,
I was just checking on.
yeah, I appreciate it. Some kind of like coming from the A.
I get that.
Uh-huh. Mhm. Oh, God.
No, it's dead. The screen was slowly fading. I can only see the one side of it.
Oh, let me mute it.
It's from 1922, so it's. Are you still doing stuff in there? How are you gonna do?
Mhm.
He's presiding all day.
Yeah.
Mhm.
Yes, ma'am.
How about what's the name? File a motion objection, defense objection to our,
To continue.
yeah,
What?
of course they do.
You ain't no.
That's fine. I'm just gonna go ahead. I'm gonna file the amended one. And then I'm going to,
I did eat breakfast. I had, or bacon, egg and cheese.
then I'm going to file,
Crazy little, 'cause I don't look at the.
I'm going to file the, I'm gonna file the, then as soon as I'm done here, I'm gonna file the, oh, thanks. I'm gonna file the, oh, let me go ahead and be looking over this other case while.
Yeah. So basically, we got.
See, this blinds because they eyes to review these cases and do our little. Yeah, that's what she asked me. Am I okay? Cause like she knows how normally I'm like on point. Yeah, yeah, because it's like I, pretty much basically like. And then I just got a lot going on, like, I mean, just like I'm. Okay, so. I got a beef with you. I'm mad at you because I heard something. Let me move this. Understand.
Judge Checker. That hallway. It's a little box. Wells into the interview.
Cause I was like. That's all. No, I said, but I do know what I said. He didn't know the one thing. He didn't know he did have issues. So, so he can't. He's feeling like he was there. Okay.
Yeah.
Okay. Okay. All right, well, I'm just making sure, because I'm like, damn, I'm a little bit different. Wait, you gonna say something? Okay, well, that makes sense then, because I was like,
That's amazing.
mute that now. If you don't talk.
Gotta hold it down.
Yeah, because it's the green.
I haven't. See it in this.
I'm just telling you. No way. No, well, congratulations to you. Walk out of here. Okay. The richest man alive. That's perfect. Sounds suitable. But no, it's not me. I'm Christina. Hi, Christina. Christina. Nice to meet you too.
Y'all gonna have to call each other C or something.
It's different. Now. It's different than the word. I don't feel like I'm talking to myself. when I say my name.
Yes, ma'am.
And I ain't gonna feel no kind of jealous when you sitting over here with my former investigator. I
That's
don't care.
So you,
That's
so,
okay. I still got his phone over. It's all right.
so you know how he is
I
then.
can, oh, girl.
He almost trailed.
Girl.
Yeah.
That's okay. It's all right. Sit over there by him.
We're gonna go see the race. We'll see which one the fastest.
Oh, I gotta have my shoes on, my no allowed sneakers that he coming out with.
I don't put bets, Dodge RTs, I done told him.
Yeah.
Yeah, coming out of, on Cortland, you know, straightaway and stuff. Bet pulled up to me the other day. I had to dust them off.
I bet you did. You know, they purchased electric vehicles for, one of the northern cities for the police vehicles.
Yeah.
All right, let's go ahead and bring out Mr. Solomon Terry.
Yes, Your Honor.
Okay. Mr. Terry, then bring out Mr. Terry.
Yes.
How are you? Oh, very great. Sears, Sears. Exactly like the store Sears and Roebuck. Sears.
Used to
no-
mean something.
Yeah, Christina, yes, Christina.
All right, give me a second. Okay, so this is position 1, 24P I004171, Solomon Terry, who's present in the courtroom with Christina Sears and with his attorney, Miss Sears, and then we have Ms. Clark representing the state. Go ahead, Ms. Sears.
Your Honor, this is Solomon Terry. Mr. Terry is 27 years old. He is before you today on a motion for bond filed by his previous counsel, which I adopt. I would like the court to know that Mr. Terry is 27 years old. He's a high school graduate. He does have some college education as well. He does not have any criminal history. He's been a resident of Georgia for all of his adult life and some of his childhood. He graduated from high school here in Georgia. Prior to his arrest, he was gainfully employed. He was in law enforcement. He meets the Ayala factors for a bond as he poses no risk of flight. In this situation, Mr. Terry did turn himself in to law enforcement and subjected himself to an interview and was taken into custody and has been in custody since. He poses no threat of committing additional crimes while on bond, as demonstrated by his criminal history, which is free of any prior infractions. He has significant ties to the community, he has a lease in his name. He resides in DeKalb County. He has family here in Georgia. His mother resides in Macon. He poses no threat to any person or any property while on bond with this court. He is currently housed in the North Fulton facility, which makes it extremely difficult for him to participate and assist in his defense. So we are asking that this court issue a bond, order a bond in support of his Eighth Amendment right, that it be reasonable. Mr. Terry asserts that he can make some bond, some payment of cash, although it's not substantial. If the court would consider a $25,000 bond, he would be able to make that payment and be released.
Ms. Clark?
One moment, Your Honor. Your Honor, the state is will ask the court if the court does set a bond in this case, the court asked the court because the court, we acknowledge that looking at the Ayala factors, that the defendant does not have any FTAs. So factor one is not triggered. He does not have a prior criminal history. However, based on the nature of the charges in this case, however, Your Honor, based on the nature of the charges, we do believe that factor three is triggered in this case. And for that reason, if the court does grant a bond, we ask that the bond be set at $100,000 cash bond, and it be a good bond. We ask that the bond be set, an ankle monitor be set, and that a curfew be established. No contact with the victim, of course, and that there be parameters established, such as there be a curfew in place, that the ankle monitor be at the defendant's expense, and that there be no intimidation of witnesses, and that there, of course, be no contact with the victim. The victim is opposed to bond in this case. The defendant is being housed at the North Fulton facility. We do not believe that that is a reason for the defendant to be released from custody. But we do acknowledge that the fact that the defendant has no criminal history, we are concerned that the defendant, at the time of the attack in this case, was a first responder. And under the guise as a first responder, Your Honor, this attack did happen. And so for that reason, Your Honor, we are asking that the defendant have no job in law enforcement until this case is resolved.
You cited Elia factor three.
Yes.
Given the nature of the charges, do you mean 4 or do you mean 3?
I mean,
Or do you mean I mean, do you mean risk of flight or do you, what?
I meant, Your Honor, I meant poses no significant risk of committing any felonies
Okay,
pending trial. So I'm talking about the fact of the fact that there was an alleged rape in this case. So factor 3.
okay. All right.
And then also factor 4, we do believe that the fact that the defendant and the victim knew each other, that there is,
Well, that was going to be a question F. So you believe that the victim and the defendant know each other and the victim lives in the Atlanta area?
or I mean, that there is some type of relationship. So based on that fact, he knows how to get in contact with her. So because of that reason, we feel that there is some form of possibility that there would be a way for the defendant to intimidate her if he is released from custody.
All right. All right. So Ms. Sears, I'm going to let you sort of respond, and I'll tell you now that I'm gonna grant him bond, but I'm thinking through the conditions and I'm thinking through the amount. What I'd like to know, there's going to be an ankle monitor involved. So what sort of curfews are you thinking? And
Well,
but
Your
go
Honor,
ahead with your response.
my client maintains his innocence and denies the allegation in whatever charges have been mounted against him. These allegations are not a result of his employment.
Well, I've already said I'm going to give him bond. I guess I'm more interested in what obviously you're advocating for your client,
Mhm.
but what sort of restrictions should he have as
He
far as?
certainly will abide by any restrictions that this court puts in place and has no intention or desire to contact the alleged victim in this particular case. He will be seeking new employment. And should this court require an ankle monitor, we would ask that it at least be reasonable business hours, somewhere between the hours of 8 a.m. and 10 p.m.
What about Ms. Clark not wanting your client to seek employment in anything that would involve law enforcement or being a first responder?
Well, to be quite frank, I don't think he would qualify with these charges pending. So I don't think that would be any hindrance to him going forward. I don't think with these pending charges that his application would be accepted by any law enforcement agency in any capacity. So I don't think that would hinder him from being gainfully employed.
Your Honor, I would still like that bond condition there.
Okay. All right. So I'm gonna grant it's going to be a good bond, $75,000. He will have an ankle monitor if one is available at the state's expense. He can take advantage of that. Put this in your order. I'm going to want a proposed order from you, Ms. Sears.
Yes, Your Honor.
To wear an ankle monitor. His curfew will be 6 a.m. to 7 p.m. No, 7 p.m. to 6 a.m. is his curfew. Let me flip that.
Thank you.
He is to no drugs or alcohol, no weapons, no social media, no contact with the victim or any potential witnesses, either directly or indirectly. There's no contact with any potential witnesses, but I would also add, obviously, no intimidation of potential witnesses. And we'll add Ms. Clark's very specific request that if he does try to gain employment, that it not be anything to do with law enforcement or being a first responder. Is there anything else you can think of, Ms. Clark, as far as a condition?
No, Your Honor.
Okay. Anything else, Ms. Sears?
My client can abide by those,
Okay.
the order of the court.
Go ahead and get me the proposed bond order then.
I certainly will.
With that, you're excused.
Thank you, sir.
All right.
I'm gonna go and draft this word and send it in. Okay, all right.
All right.
Right.